can request a copy of the agenda or all the documents constituting the agenda packet. There's a procedure for asking for a mailed copy of the agenda. Most of the newspapers used to do this. I don't know who does it now, but they ask for a copy every time the agenda is posted. And they have a right to comment, okay? So this becomes an issue. As I said, every agenda has to have a provision for public comment. It has to be either before or during the consideration of the item. You don't need to allow comment that's off topic for the school district ever, and you don't need to allow comment that's off topic for a special meeting if it's a special meeting. You may limit the time, place, and manner of public comment. You may limit speakers to a specific amount of time. You don't necessarily need to require things like AV equipment for members of the public. If you may choose to provide that if it benefits you, but if a person says, I want to put on a 15-minute PowerPoint before the board, you can say no. You can provide a content-neutral time, place, and manner restriction, so you can say everybody is allowed to address the board for 2 minutes. When you have a particularly difficult issue, God forbid a school closure or something that gets a lot of people to come to the meeting, you could have hundreds of people in the room. You might look at your watch and say, we've only set aside 45 minutes for this item, and then do the math and figure out that you're going to be there for a long time. It's okay to say, we'll allow 5 minutes for each speaker if it's a light agenda and there are a small number of speakers, and you can constrain it down to as little as 2 minutes. But if you get to the point where you say, I'm sorry, but you're going to have to talk amongst yourselves and appoint 10 spokespeople, not okay. You can't say, I want the people that are pro to sit over here and the people that are con to sit over here, and we'll do a head count and we're not going to let you talk because we already know what you're going to say. You're not allowed to do that. And I would really recommend that you not, if the math works out that you're giving people less than 2 minutes, that you find some way to either extend the length of the meeting or continue it to another time so that everybody gets an opportunity to speak. The Brown Act does treat standing at this podium and addressing you face to face as the gold standard for how you communicate with public officials. Even in today's day and age, when that's not necessarily the most effective way to make a complicated point. You may say, you have the opportunity to write us, you may call us, you may corner us at the grocery store and start haranguing us about how we're doing our jobs wrong. All of you have many opportunities to talk to us, and that's why we're not going to let you stand here at the podium and repeat all of the stuff we already know. It's a violation of the Brown Act to deny somebody that opportunity. Because generally speaking, they're not talking to you, they're talking to the people behind them, and this is their chance to have a large audience to hear what it is they have to say, and they will not surrender that. But you have a right to lubricate the process and keep it going smoothly. You have the right to encourage courteous and respectful debate. You do not have the right to deny somebody the chance to speak if they are being discourteous and disrespectful. You can ask that they be courteous and respectful, but you can't say, I'm taking the microphone away from you or turning the microphone off because of what you are saying, including if they are calling out individual members of your staff or individuals on your board. I know a number of school boards desperately want the public to believe that if they have something unkind to say about an individual member of staff, particularly even if it's like a classroom teacher, that they not embarrass the person in a public setting. But the Brown Act doesn't allow that kind of restriction, and the First Amendment actually requires that you allow that type of speech, even if it is difficult to accommodate and difficult to hear.
So allowing these people to speak is basically a First Amendment right.
Yes.
But what about someone that, may be discourteous? Can you remove someone from attending? So by law, they have to have the ability to attend, speak, or hear
Yes.
what's going on.
The board president has limited authority to remove a person from the meeting if they are disrupting the meeting. Disruption, in my view, and this is only one person's view, there's not a whole lot of case law about this, is if they are trying to prevent the meeting from progressing. If they are within their 2 minutes and they sit down at the end of the 2 minutes, it's difficult to say that whatever it is they said during those 2 minutes was a disruption of the meeting. If anything, it was the meeting. It was part of the meeting. But if a person is repeatedly standing up and shouting people down or booing or otherwise disrupting and interrupting other people, the board president has the power to ask that that person be removed. It's rare that that's ever exercised. Usually, it's a person who's probably already known to the board and whose behavior could be anticipated if it's an issue that's very important to them. And we have had districts that have found it necessary to ask the local police jurisdiction to attend the meeting and be available, just to be a reminder that there is a courteous way of making a point, and then there's disrupting a meeting, and that you can be removed. There is also a procedure, I've never seen it used in this county, to clear the meeting room if a meeting gets grossly out of hand.
It happened in our district.
Before my time, I hope.
Yep, before your time, your dad, I think.
Okay, so it's entirely possible to clear the room. However, there are special rules and procedures that apply, which include if there are any representatives of the media that are present, they have to stay. So they're allowed to stay.
Right.
But you can kick everybody else out and proceed with the meeting. That really should be a matter of very last resort.
But it's safe to say that any person can have the right to listen or speak, because that's basically First Amendment rights.
Correct.
And in violation of that is wrong.
Correct. In addition, you're not supposed to condition the right to speak on anything. So if a person stands up and says, I'm a resident of Redwood City, and you say, you're not a voter, sit down, they have the right to address you, because every citizen of the state of California has an interest in the operation of this school district and the education of its children. So anybody from anywhere can come and talk to you, and you can't deny them the right to speak, even if they're not a California resident.
So even at ad hoc committee meetings and stuff like that, they still have the right to speak, right?
If it's an ad hoc advisory subcommittee, it's not subject to the rules of the Brown Act, so you don't need to invite the public at all.
Okay.
If it's a subcommittee meeting of another kind where the Brown Act rules do apply, you do need to post an agenda, and there does need to be an opportunity for public comment.
Got it.
But I would call that a special meeting, so it would have to be within the scope of whatever it is the subcommittee's meeting about. There are citizens who take every opportunity to address elected officials, whether it's on a topic within their power or not, and they will go to every meeting and they will make their point, if it's the same point over and over again. At a subcommittee meeting, you could plausibly say, that's not within the jurisdiction of this agency, so please take it to the appropriate jurisdiction.
Can I ask one question? If, let's say we did have a really unruly person present, is it all right for the president of the board to take a short recess so that perhaps somebody could calm them down and then come back?
Yes, I have on a couple of instances been asked to in advance prep a board president about kind of the steps you go through, consider it progressive discipline of public members that are intending to disrupt a meeting. Sometimes they state in advance because they're sending blast emails out to everybody saying, we got to take back the school board and we're going to engage in acts of civil disobedience during the board meeting. Generally speaking, when something starts to get out of control, it's helpful to politely interrupt and state what the rule should be, use the gavel sparingly, maybe take a recess, have somebody go and talk the person down a little bit, state that you're really out of line, and if you do prevent the proper progress of the meeting, that the next step will be to remove you. Sometimes they're grateful to hear that because they really want to make a scene, and you can work something out about, okay, we'll drag you away. But generally speaking, it's a good idea just to state what it is you intend to do, and then do it, and do it without anger and without, just very, we are here to hear from members of the public, not from an individual alone. Would you please sit down? Your time has passed. Your time is up. Generally speaking, the most frequent issue in this regard is when you have a speaker who's given their 2-minute limit and they feel passionately that this matter deserves more time before the board, and they exceed their limit, and they continue to talk and refuse to obey directions of the presiding officer of the meeting, who is the board president, that their time is up and they need to sit down. And it's always a dicey proposition about knowing exactly how much forcefulness is appropriate before it begins to look like you're being overbearing. But at the same time, most of the people in the room are grateful that there is a limit, and they do know what it is that person is saying, and they appreciate moving forward and hearing from somebody else. So it's about striking a balance and being respectful and courteous. When are closed sessions permissible? This is item 5 of 6, and I'm pleased to tell you the last 2 are a breeze. Closed sessions are permissible only for matters listed in the statute, and if it's not in the statute, you can't have a closed session. We work with the superintendent to figure out the best way to get something agendized in a totally compliant way. Matters that you learn in closed session are confidential. It is a crime for a member of a board to disclose outside of a closed session matters that they learned by virtue of a closed session, with a couple of exceptions. The exceptions being, if it's to call the DA and say that you believe that a crime has been committed, that wouldn't be a crime to disclose the closed session item. And there are a small number of exceptions. If you have that kind of problem, by all means, call our office and get good advice about whether or not you can disclose from closed session. But generally speaking, you should have a clear idea that once the dome has come down over the board and you're talking about closed session items, that you can't then use that discussion later outside of that group, including in talking with constituents and saying, well, I voted yes because, but then this other board member voted no because. The fact of the vote is going to be public because it's part of the action. You voted yes. A member of the public says to you, why on earth did you vote yes on that in closed session? You might want to say, but you really shouldn't, because you might wind up getting dragged into a conversation where you begin to disclose material that you learned because of closed session. It's not a violation, it's not information that you learned from closed session to say, I believe very strongly that we needed to do X. It would be a violation for you to say why.
Right.
And that's why it's difficult to get out of those conversations once you're in them. What are the consequences of violating the Brown Act? The first is criminal penalties, okay? So if any member attends a meeting of that legislative body where action is taken in violation of the Brown Act, and where the member intends to deprive the public of information to which the member knows or has reason to know the public is entitled, then that person is guilty of a misdemeanor. And all people who attended that meeting and had that same intent are guilty of a misdemeanor. So 2 things are required. The first is it has to be an illegal meeting with an illegal action, and it has to be with the intent of depriving the public of information to which the public is entitled. It is actually relatively hard to violate the Brown Act in a criminal way. Most of the technical violations that we see are done not with the intent of depriving the public of information to which they are entitled. If anything, they tend to be preliminary to some later action of the school board where the intention is to vote in a public setting, and of course everybody's going to see how you vote. But maybe you had a conversation with 2 board members in advance of that meeting, and that was a technical violation. Prosecutions of the Brown Act in a criminal sense are very rare. They do happen. I heard somewhere, I've been unable to verify this, but I heard somewhere that in the entire history of the Brown Act in California, 0 days of jail time have been served by any public official for violating the Brown Act.
No.
There have been convictions, but they've been overturned on appeal, usually on technical grounds. But that's extraordinary. And I think it is a testament to the fact that there are a bunch of other remedies that are available, and generally speaking, the courts don't like to find that a person acted with that evil intent of depriving the public of information. But it is true when someone says to you, it's a crime to violate the Brown Act. Not every violation of the Brown Act is a crime. Only specified provisions of the Brown Act can constitute a crime, and it requires that special intent of wanting to deprive the public of information to which they are entitled. There are also civil remedies of the Brown Act, which include the district attorney or any interested person, so that could be a member of the public, whether they are a lawyer or not, can bring an action to overturn an action that you took. And there are requirements that they notify you that the Brown Act has been violated and give you the opportunity to correct it. If you choose not to correct it, you could potentially be ordered to correct it by a judge. And at that point, you may be required to pay the attorney's fees of the person that brought the action. Again, these types of actions are fairly rare in our county. They're more frequent in other jurisdictions, but in this county, it's not often that a person goes to that length. We get letters from the public all the time, people who believe that the Brown Act has been violated and stating their reasons why they believe that. In many cases, those people are incorrect, either on the facts or on the law. Generally speaking, our office responds to those letters by explaining why we believe the law was complied with, if we can, or if not, we would meet with you and suggest that you take the action again in order to cure the violation. So when people say the Brown Act has been violated, they try to make it sound like any violation of law is an act of moral outrage, no matter what. Well, the longer you spend on the school board, the more you realize that there are so many laws governing school districts and so many laws governing public agencies that violations of that law occur all the time, and the seriousness has to be judged in context of what compliance can be brought to bear on the situation to fix it. Because many times the law is violated simply by accident, and it's a matter of getting into compliance. And there are procedures that are allowed for getting into compliance that are relatively easy. The one warning that I would have is that many things that school boards do are subject to time constraints, namely personnel actions that are required to be taken by March 15th or May 15th of each year. If you violate the Brown Act with regard to your March 15th layoff notices or notices of non-reelection, and somebody writes a letter that says you violated the Brown Act because it wasn't agendized properly, they're going to say you have to take the action again to cure the violation, but they're also going to say you're going to have to wait till next year to do it.
Right.
Okay? And if it's a matter of non-reelection and the person is in their second probationary year, they're going to say you can't ever do it at all. They're going to say if you blew it under the Brown Act, your action was void, so you need to rescind it, and you can't retake it. So
Happened to us.
I would urge special caution with regard to those items, or items with time deadlines like, excuse me, time deadlines like responses to grand jury requests or adoption of a budget, your Williams Act or your Williams settlement certifications, et cetera. If it's under a time deadline, that's when you should be taking extra special care not to have technical violations of the Brown Act, because those can't be fixed after the fact. Let's see. As I said, there has to be a notice of violation and an opportunity to cure. What I would say on this topic of enforcement and remedies is that courtroom consequences to Brown Act violations are difficult to obtain and are fairly rare, both criminal and civil. But media and political consequences of Brown Act violations can be swift and severe and difficult to explain, even when there's a good legal argument why the Brown Act wasn't violated. And I think this is one of the reasons why it's popular with people that oppose an action taken by a board. They say Brown Act, what they're really saying is, I just disagree with the outcome, not with the process, but with the outcome. And they believe the Brown Act is the best way to hammer on that problem. And it's our job to try to walk you through whether there was a problem, and if so, how to correct it going forward, how to correct it retrospectively. But many of you know that by that point, many members of the public will have made up their mind either pro or con, and that's why it's best to have procedures that you have confidence avoid the problems at the outset. So I believe I've hit everything that I intended to, other than getting you the handouts.
I do have,
question.
oh, go ahead, please.
I know that at one time, school districts were not, they didn't put down the item on the agenda to explain to the public what it really meant. And it happened in our district once. And I'm not sure, but I think even Quentin Cobb at that time helped write some legislation. So I wanted to make sure that I understand that it's still this way, that agenda items must be posted in such a way that the public will understand what action may or may not be taken, but not to be surprised. And so, is that still appropriate? Is that still?
Yes,
part of the
it is more an art than a science, because too few words and you aren't giving fair notice of what you're actually doing. Too many words and it's gobbledygook that people can't really interpret.
Well,
So
yeah.
generally speaking, it's a sentence or two, consideration to adopt, blah, 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 but not going on for a full paragraph for each item.
Right, right.
More like 2 or at the most 3 sentences. If it can be said in a sentence, there's nothing wrong with that.
But so that they understand what action will be taken, might be taken.
Yes, so the way the Brown Act is written, it says any matter for discussion or action. Some boards find it helpful to specify on their agenda whether a matter is a discussion item or an action item,
Right.
and to say. And in many cases, it's discuss and act.
Right.
And if you only put discuss and you didn't
And
put
vote on
act,
it.
you pretty much precluded yourself from taking action on it because the
Exactly.
public might not have come because they relied upon the fact that it was only being discussed.
Right.
And really, action on an item can be a motion, like a motion to table the item. If it's simply a presentation, discussion is probably the best description of what's going on,
Right.
and a person can fairly guess whether or not they really need to attend the meeting if it's only going to be discussed and not acted upon.
Does,
But you're right, that it's about fair notice to a
Yes.
person that is considering whether or not to stay home in front of the TV
Right.
or to actually come out and watch the school board do its business. And if you believe that the agenda gave them notice that if they didn't speak now, they would have to forever hold their peace, then you've really hit the magic point, the sweet spot of that.
Okay, so that was one of the things I wanted to make sure we had on that. And then the other one is, what's your opinion about if the school board decides to meet at someone's house?
It is not per se illegal. It presents some problems of practicality about whether it's actually accessible to the public. You would have to post an agenda like anywhere else, and you would need the agenda posted at the district office to say where it was, so your address would be out there for everybody to see. Not that you might not necessarily care about that. The problem that we most frequently face, and it is done, there are districts that do this, particularly if it's only going to be for a closed session, particularly if it's something where it's going to be an informal roundtable, like a superintendent's evaluation, might be easier to do in somebody's living room than in a public building. But very few private homes are ADA accessible. And
Especially in our neighborhood.
and it's tough, it's tough to prove that it is. And you wouldn't necessarily want somebody walking around with an ADA inspector showing that your stoop doesn't have the proper turnaround for a person who's reliant on a wheelchair or something like that. So
The door has to be open, is that correct?
the door has to be open, and again, this is one of those areas where usually when it's done, it's not done with any intention whatsoever of excluding the public. The door is open because it's a public meeting. But the practical realities for a lot of people are they can get from a ADA accessible parking space to an ADA accessible point and address the board. And while it may be rare that you will necessarily have somebody who requires those kinds of accommodations, who wants to come to speak and address the board prior to a closed session about the superintendent's evaluation, if you had the perfect set of facts all coming together at the same time, you could potentially have a problem.
Okay.
So it would be possible to comply, just you'd want to do your homework about whether it was really fully compliant.
Okay.
One of the questions I did have is I was kind of confused on what constituted a meeting that we could attend and cannot attend. So I want to thank you for what you were talking about. If it was held in ceremony, we don't run into each other, we don't discuss business. We could actually hear what was going on. And then I remember you talked about you can't. We have to have transparency and allow everybody to speak, give them their 2 minutes. We can't tell them to do this or that. And also the advice on how we can respond to that. And then also you talked about the goal is technical compliance, and we must meet all qualifications to do the Brown Act. But just say, for example, there was the disruptive board member that I didn't want to come to a meeting, and they didn't want to talk. They just wanted to listen to what's going on. Can I say, no, you can't listen, no, you can't do that, no, you can't be here, you're in violation of the Brown Act?
So the way this most frequently comes up is when there is a subcommittee meeting that is subject to the Brown Act, and it consists of 2 members, say a standing committee on some topic, and then a third board member wants to attend the meeting. So it's a public meeting.
Yes.
And they want to sit in the front row and look at their colleagues discussing this item about which they might feel very strongly. And maybe they asked to be appointed to this subcommittee, and maybe the board voted and 2 other people were selected. That happens. It's covered by a provision of the Brown Act that allows other meetings of the same public agency, so long as there's not a caucus to talk about the issue amongst the 3. So my My preference would be that if there were a subcommittee of two of you, and then a third person wanted to attend the meeting so that they could hear what was going to be said, and they attended the meeting, they are free to attend the meeting because that's actually very clearly allowed under the Brown Act. What is less clear is what the legal consequence is if that person gets up to speak as a member of the public, because at that point, it's a meeting of the school board. When that person speaks from the podium to the two board members and says, here's what I think, they have an opportunity to say that. They should wait until the school board has met and posted an agenda.
Exactly.
So generally speaking, it's not illegal for them to sit and listen. It's potentially troubling if they use it as an opportunity to communicate their views to the two board members, because then that is arguably a meeting of the school board, not a meeting of the subcommittee.
Got it. So just to review the things that we were talking about, what constitutes a conference and a meeting, what's public and what we can attend, cannot attend, what would be construed as a caucus or interaction or public opinion, so that it's clear that they can attend the meeting, but they just cannot speak.
They can attend the meeting and they should not speak.
Should not speak. And then not allowing them to go to that meeting, or not allowing anybody to go to that meeting, is basically a violation of First Amendment rights.
It's open to the
No, I won't go that far. And the reason I won't go that far is the Brown Act itself is a violation of your First Amendment rights. Okay? So when you ran for school board,
By saying you should not speak, that.
yeah, right. So
Yeah.
this advanced topics in constitutional law, you pushed a button on me. I'm going to talk about constitutional law now. So before you ran for the school board, as a resident of this district, you had the right to talk to the members of the school board. You then run for the school board, and all of a sudden, you lose that right, okay? So you gave up a First Amendment right by running for the school board, because now it would be committing a crime for you to try to talk to people who you voted for in the last election, or voted against, as a case may
But
be.
say, for example, that person didn't speak. There's not a violation of anything, but it still allows them to listen.
But I wanted to get to it because there are two components of the First Amendment, because there's the speech clause, and then there's the right to petition government, and they're two independent rights. So essentially, and we have pretty clear case authority on this, it is a violation of the First Amendment to have a law that says that you can't petition your government for redress of your grievances. And you are both an elected member of this board and you are a constituent of this board. So the people sitting on the dais with you are your elected officials and you are theirs. And this rule prevents you from having what every other person in the Jefferson Elementary School District has the right to do. But the First Amendment is not absolute. It allows certain types of restrictions so long as it is in furtherance of, it's narrowly tailored and in furtherance of a compelling government interest. So the Supreme Court has said, Congress shall make no law to restrict the freedom of speech. We'll tell that to Julius and Ethel Rosenberg. They were put to death for exercising their right of free speech. You can have a law that restricts someone's speech. It just has to be a narrowly tailored law to advance a compelling government interest, and then it's consistent with the First Amendment. And the Brown Act and other anti-corruption measures in other states, the case law that I'm thinking of was out of Nevada, but the Supreme Court blessed off on it. If there is a rule that's designed to be anti-corruption, by requiring that your speech occur here in public and not in private, then it is narrowly tailored and it advances a compelling government interest. And in the same way, if the board were to say, we want to have a board policy that says that board members cannot or should not attend subcommittee meetings, I could argue either way, frankly, about whether that's a good idea. But I can definitely say it is a constraint on your right to petition your government because you're forbidden from attending a meeting that other people in the school district are allowed to attend. But you can attend the school board meeting and have all the same rights as everybody else. It's not saying when you can talk to your fellow board members. It's not saying whether you can talk to your fellow board members. It's saying when.
Got it.
Where. And so it's essentially saying, it's not a prohibition on you attending that meeting. It's saying if you're going to meet, do it with all of us.
Yeah, so basically, I was one of the proponents to rehab this Brown Act study session. The reason being is that I wanted to hear, from the horse's mouth, understanding of fiscal importance as a taxpayer and as a board member, bond issues, which is a lot of money, $63 million coming within the next 5 years. And I was told I cannot attend, even though I only wanted to listen, even as a taxpayer, because I am paying for those, and understand what those issues were, and understand what's going on, and not have any concurrence, not have not anything to say, to the point that, you know, the citizen of that head of that bond committee says, no, you can't go. And I go, that's a violation of my civil rights, just to listen.
And I don't know if this is what you're referring to, but this was a committee of the public for passing a campaign committee for a particular measure that was on the ballot, comprised of
And a
citizens.
person had called me saying that I cannot attend, even though I just wanted to listen.
Okay, so the committee is a campaign committee.
Correct.
Which is under,
It,
It was not a district committee.
yeah, it's entirely up to you to decide whether you thought that violated your rights, but it's not the school district's violation, because it wasn't a function of the school district can't control who attends that meeting or who doesn't. It's illegal for the school district to have a committee of its own in furtherance of the bond measure, because you're prohibited from engaging in political activities.
Is
You
it
can be
also-
members of private groups that do it. That's not illegal for you to be a member of that committee. But the civil rights law only controls what government does to you, not what other people do to you. And a campaign committee is regulated by the government, but it's not itself the government. So I thought we were talking about.
but it's a public committee.
Well, no.
What if the school district committee that evaluated doing the campaign were the same ones that asked people to be on the campaign committee? I could go on, but I think it's a little deeper than what he's saying.
This is actually off topic, but the prohibition on use of public funds or facilities for campaigns is only triggered when there is a matter on the ballot. So for me, the moment in time that matters is when the school board votes
Right.
to direct the superintendent to tell the county superintendent of schools to place a measure on the ballot. When that moment happens, the school district is supposed to get out of the business of
Exactly.
talking about the bond measure
Exactly.
from an advocacy standpoint. But up to that point, they can have a district committee, and it is the district's committee, to evaluate needs, to do feasibility studies, to figure out whether or not the
Right.
voters.
But then
will
if
vote
you
for it.
had two board members on that committee held inside district office, how can it be?
That
It
never,
wasn't.
that
It
never
wasn't.
happened in this district.
No.
That didn't happen in this district.
Then what was that meeting then?
At the restaurant?
No, inside the
So
district.
you were talking about maybe the feasibility when the district formed a committee to explore the feasibility
So
of
the
a
district formed a
particular.
committee, so it kind of trickled down.
That was prior to
So
board
that's,
action.
that's what I'm wondering, what the violation would be. The district creates a feasibility committee that creates a campaign committee.
No, a feasibility committee couldn't create a campaign committee.
Then how did board members become part of that committee?
Because as citizens of the school district, they're allowed to join whatever private groups they want, as can anyone really, so long as it's not an incompatible public office, which is another topic. So, I mean, I don't know based on those facts.
So is it safe to say that it should be out of district control on what committees you can attend and what cannot attend? And I'll say it straight up. So my superintendent telling me I cannot go to that meeting is a violation of my civil rights.
I don't know what you mean by that meeting. You mean a pre-measure feasibility committee meeting?
Both meetings.
No, this was after the feasibility study.
No, he's talking about
The
feasibility.
measure was already placed on the ballot, and then we were in the campaign stage. And there was actually two board members that were asked to be on that campaign committee. Actually, a third board member ended up being on it, and because of that, one board member voluntarily stepped back, and
Okay.
stepped off because the public were saying, this appears like it could be some type of violation. So just because there might have been an appearance, certain board members voluntarily stepped back. But at that point, I know there were people who asked Mr. Otaidi to please not come to that when there's two other board members there.
So
But this was after the feasibility.
So after a
study.
feasibility committee, a campaign committee is formed with 2 members. And as a taxpayer, so that's not under district, because it's a
Well,
ad hoc committee? I mean, this is, that's, this is,
had-
these committees and these things that we can attend, I think is where the tension is because why,
I think I
Our
understand the
members-
situation. Let me answer it this way.
Yeah.
It doesn't matter whether it's a district committee.
Mm-hmm.
If we're now talking about any group formed by the district or even a private group that is formed for the purpose of discussing some matter that relates to the school district, there cannot be 3 board members on it. Cannot be. And under that circumstance, whether or not there might be an exemption that would apply if you were simply to be a spectator in that room, it would be a matter for that committee to decide whether or not they even wanted spectators. But for the most part, it's not because you can't be a member of that committee, it's because if there are 3 board members in the room and district business is being discussed, it's no longer a meeting of that committee. It's now a meeting of the Jefferson Elementary School Board.
even as a spectator? As we described
Yeah.
at,
If it doesn't qualify
As-
for one of these exceptions,
yeah, as we
yes.
described at 7:53, what a conference and a general public meeting would be. And it would not be a
Oh,
violation of.
no, I'm sorry. Other public meeting, it means a meeting of a public agency, not just a large meeting. So it would have to be, it would be a question of whether or not that committee was having a public meeting within the meeting of the Brown.
It was a public meeting.
But, okay, then I guess I don't understand, because if it's a campaign committee, it's not a public
It
meeting.
wasn't a public meeting. That wasn't a public.
Perhaps it would be for the
I was
best,
invited to
given,
join, so.
given the sensitivity of the issue and the clear interest of this, that instead of me trying to shoot from the hip, that I should confer with Kathy Miola and with the superintendent and have them investigate further and give further advice. Because at this point, I'm trying to answer hypothetical questions, and I feel like there are a lot of facts out there that I might not fully understand.
Please.
So rather than try to understand what those facts are, it's probably better for somebody with a better position of knowledge to investigate it and give you advice about the outcome. But what I wanted the takeaway to be from this study session was that 3 members of the board gathered together to discuss something that has no bearing on district business, no relationship to district business. It's the YMCA steering committee or something like that. That's not a Brown Act violation because you're not talking about the school district. But the minute you start talking about the school district, if there are 3 of you in that room, it's either going to be a posted agenda or it's got to be one of these qualified exceptions. And you need to know in advance if you're going to rely on an exception because they are somewhat technical.
Can I give an example of something we shouldn't do? Say, one of our administrators is having a wedding, and they invite all of us to go. And we sit at one table together, and one member decides to say, I have just met this wonderful principal way back in some other city, and I think we should hire him the very next opening we have. He's really good. I met his wife, and I happen to say, I think we're violating the Brown Act, so let's not talk about anything else about this. If the time comes, that person comes through, that's a different story. And I was told, baloney, they can talk about what they want because we're out at a private party and it's okay. So that's what we're trying to say, is we cannot talk about district business no matter where we're at, because once there's more than 2 people, then we violate the Brown Act. Is that correct?
Yes, because that element of discussing the specific application of specific issues that are within your jurisdiction is going to be a violation if 3 of you are talking about it, no matter what.
Right.
The exceptions that we're talking about are when you're not talking to each other about it. It's when you're at these other meetings and not addressing district business. You can be at CSBA. You can be at a community forum about school violence, interjurisdictional, city, police. It could be, discussing, new planning policies for the city that might affect your enrollment or whatever. You can attend those meetings because you're not discussing the specific application of matters within district jurisdiction. The minute you're talking about that, it doesn't matter if it's somebody's wedding, it doesn't
Yeah,
matter if it's a political
exactly.
campaign meeting, it's a Brown Act violation, and the public has a right to have that discussion contained entirely within this room with these people present and an agenda outside.
So, and just to add on that, I mean, there are reasons why Brown Act are used to enforce and to regulate, but on my side, for the Brown Act to be used as a constraint to scare isn't right. I totally understand what Mr. Zerwilla is saying, is that there are times that we shouldn't be talking about district business, which I think we're pretty good.
Oh, yeah.
But there are also times that
It's mobile
it
as
shouldn't be used as a constraint from observing and listening and basically doing our job as elected officials, elected by the people, for the people.
So long as you're talking about interactions with constituents, absolutely. Your fellow constituents who also happen to be elected members of the board, not so much. There are very specific rules that govern those interactions.
Understood.
And that's what the Brown Act is all about. It's a unique constraint on what would otherwise be your right as a citizen that we've agreed is a worthwhile constraint to avoid whatever set of bad consequences were seen in the early 60s when these rules didn't exist.
So I was just going over what we were talking about. It seems safe to say that we should agendize standing committee agendas.
If we even want to keep having standing committees, I think we
Well,
need to
that's
discuss
something we
that.
should discuss.
Yeah, and
Well, we once went to, two board members, myself and another board member, went to Arizona to interview a candidate for superintendent. And they took us to lunch after we went around, did all the interviews and everything. And we sat there, and there was the superintendent and the school board member and all, people sitting around there, and they were saying, so all of a sudden they're talking to each other, and they said, oh, they started talking about what they're going to do. I'll meet at your house, and the other members are coming, and I said, are you having a meeting? And they go, oh, yeah. I said, don't you have the Brown Act? Don't you follow the Brown Act? And they said, what's the Brown Act? And then when I told them, they said, my gosh, how do you guys ever get your business done? And you're right, that's exactly how people feel, because they think they can sit around and do this, but obviously, way back when, something happened and things weren't done correctly, and so now we have the Brown Act to contend with.
And I personally believe that the existence of the Brown Act and compliance with it avoids a number of transparency scandals that I think plague local jurisdictions in states other than California, and plague jurisdictions in California that don't comply.
Exactly.
I've been made aware, I subscribe to a number of school law mailing lists and news clipping services that will talk about school board scandals all across the country, and the scandals that happen in other states are very frequently a matter of transparency, and I think that this is a tool for making sure that you can plausibly say, I didn't make that decision until I voted, and you know why? Because I followed the Brown Act.
And so I want to thank you for your time, because one of the things that I did, why I pushed so hard at our last retreat for a Brown Act, is that we do believe in more and more transparency, because nothing should be non-transparent to the people.
Except for things that are
Oh, that, of
negotiated.
We have those listed down, we know.
Yes, as transparent as the legislature has deemed wise. Thank you.
All right, thank you very much.
Now we get our papers. No.
I have to email them to you because
that's right,
they're
that's right,
soaking
that's
wet.
That's right. Thank you very much, this was good.
Okay, thank you. Good night.
Are we convening to a closed session? No. I don't know why, for some reason I thought we had a closed session.
Not on the agenda, sorry.
A
Not on
motion
the
to adjourn?
Second.
Oh, we don't do
motion.
that. You just close the meeting.
So we will adjourn at 9:17.